Prior to starting Copo, he was a litigator at a firm called Deschert LLP, which is one of the largest and most prominent law firms in the world. They have 900 lawyers worldwide and almost $1 billion a year in annual revenues. Before law school, and what's particularly interesting about Wayne, I think, is that he practiced public relations at the Star Group, which was a one-time advertising age top 100 marketing communications firm. In his 4 years there, he developed and executed public relations and marketing initiatives on behalf of regional, national, and international clients, and while there, he cultivated relationships with journalists and secured dozens of placements for clients in national and regional media outlets, including USA Today and the Wall Street Journal, regional television network affiliates, and national trade media outlets. He graduated in 2009 from Georgetown, where he was senior special projects editor for the Law Journal, and he graduated magna cum laude from the Public Communications School at Syracuse University. Wayne, I'll let you take it over from here.
Thank you. Thanks for joining us this afternoon. We are here today to talk to you all about engaging the court of public opinion, both for your firm and your practice, but also for your clients. And we're very lucky to be joined by two members of the St. Louis media community. Closer to me is Jeanette Cooperman, who is a staff writer at St. Louis Magazine. And to her right is Robert Patrick, who is the federal courts reporter for the St. Louis Post-Dispatch. These two journalists here are going to give you nuggets that you're going to be able to use immediately, again, for your practice, your firm, and for your clients' cases. We are also scheduled to be joined by PJ Rendawa, who is the investigative reporter for the local NBC affiliate, KSDK. She got called out on an assignment, which interestingly involves a legal dispute that we'll get into a little bit later. But I want Jeanette and I want Robert to briefly introduce yourselves to the group. Tell us a little bit about what you do now, how you got there. I would like to know in one word what your interactions with attorneys have been like previously, in one word. Choose wisely. And finally, for any attendees who have only 1 hour in St. Louis of free time, please give us one thing for them to eat, drink, see, or do. Jeanette?
Okay. Can you hear me?
Yeah.
My name is Jeanette Cooperman, obviously. I've been staff writer for, I think, over a decade. I was the editor-in-chief for a while and hated it, really missed writing, cried, begged to go back, and they offered me the job of staff writer. Before that, I worked for 10 years at the Riverfront Times, which was an alt news weekly here, still is, doing investigative reporting and a little bit of everything. So let's see, my one word for my interactions with lawyers, I had to think about this, would be revealing. I'll just leave you with that. And I think you should go in 1 hour to City Museum because it's a quirky, edgy side of St. Louis that you might not otherwise see.
I was going to say the same thing about City Museum because just as a visitor, it's a great place to go, but as a lawyer, you're going to go there and say, I can't believe they get away with this.
Right.
So I'm Robert Patrick. I've been here in St. Louis since 2004. I was originally covering St. Louis Circuit Court, so just the building over there, I think, or over there. And then I've covered federal court since 2006. So I struggled a little with the word on, I'd probably say cautious as my interaction, relative to my interactions with lawyers, because it's, or maybe complicated, one of those two.
Basically.
Okay, thanks so much. So before we get into the details and the nitty-gritty of our conversation, I want to give you some context for why we're here with a panel of journalists at MaxLawCon 18. I was fortunate enough to be on episode 72 with Jim and Tyson. As I joke, it ran December 2017, so it was a nice early Christmas, Hanukkah, or Kwanzaa present for listeners. And it is clear that attorneys should be thinking about and using the media in connection with their marketing, but also in connection with their clients' the services they provide their clients, the actual providing of legal services to clients. From a marketing perspective, when attorneys talk to the media, they're likely going to be doing it in a couple of limited contexts. One is newsjacking. We have a particular advocate for newsjacking with us at this conference, but Mitch discussed newsjacking. I won't go into it in any more detail, but in addition to newsjacking, there is the art of attorneys building relationships with their local reporters, with their beat reporters for their courthouse, or for our staff writer from their local monthly lifestyle entertainment magazine. Because as cases come up that aren't in your firm, but are in the real world, that are newsworthy outside your firm, you have the opportunity to comment on those cases. And by doing so, you are going to be able to show referral sources, prospective clients, and other members of the media that you have some type of expertise. And if Robert is writing about the tribulations of the current governor of Missouri, and you're a white-collar criminal defense attorney, you better be emailing Robert and saying, hey, Robert, I saw your coverage recently about the governor. I'm not involved in the case, but I've had cases before where I've dealt with X issue. And guess what? Robert might get back to you and say, that's great, I'm not working on anything right now, but next time I have something, I'll give you a call or I'll email you. So there's a marketing component for you talking to the press. In addition, thank you, Tina, you get good SEO benefits from talking to the media because you are getting your name in a high-value, legitimate, credible publication like the Post-Dispatch or St. Louis Magazine or whatever your local newspaper is. So there's very much a marketing component here. But many attorneys don't understand or don't realize that they can ethically, strategically, and proactively talk to the press about their clients' cases. And when you do that, you're going to get another round of benefits. First, you can actually help resolve the case more favorably because you might be able to encourage a favorable settlement depending on what side of a case you're on. You might be able to find additional plaintiffs or defendants based on news reports when an article runs about the case that you're involved in, and now you get a phone call. Someone read that article. Now note, they didn't go in Pacer, they didn't go into your local state court system, but they read the article in their daily newspaper where you're at. And they call you and they say, I had the same problem with that company, or I had that same problem with a different company. Or perhaps someone comes out of the woodwork and says, I'm not involved in the case, but my brother used to work at that company, and he has this memo that I think you might want to know about. Or I have some documents, or I know somebody you might want to talk to. They might have some information. In addition, depending on what kind of practice you have, if you're in a high-profile criminal or white-collar criminal defense case, you should be talking to the press as a way to rebut the adverse publicity that is likely going to taint the jury in a year or 18 months. Very important to remember that prosecutors are very media savvy. And guess what? They have relationships with Robert, even if he's not willing to tell us that. Prosecutors who are smart and media savvy are going to go to Robert ahead of time, let him know about the indictment that's going to be filed tomorrow or in a couple days, and you as a defense attorney are on the outside looking in unless you are quick and you are able to respond publicly to those cases. So you have a client resolution benefit here. You also have a client relations benefit. There are many practices in here where clients want you to tell their stories. They don't want other people to suffer the way they've suffered. They don't want people to go through what they've gone through. And by you telling them their story, you're doing something most attorneys don't know how to do or aren't comfortable doing. That's going to build a relationship with that client. It's going to lead to better referrals. That'll lead to more forceful testimonials, online reviews, etc. And finally, like newsjacking and like the general marketing, you'll get some marketing benefits from talking to the press about your clients' cases. Material for your website, material for your social media feeds, for your email newsletter. In addition, you'll get SEO benefits. You'll wake up referral sources and prospective clients who may have not thought about you for a while, but they see you in the newspaper litigating a case or advocating for a client, and you get that benefit. And I'll add, when you are involved in a case actively and there's a news report about you and your case, that is a much more forceful marketing tool than simply commenting on somebody else's case. Does anybody in this room think, really, that Michael Evanetti will ever have to market himself ever again? No, because you are all watching him litigate in real time, and you are all thinking, even we as attorneys are saying, damn, if he was my attorney, he'd be out there doing that same thing for me. Now, we all know that he has a case that's like a once in a country's history type case, but nonetheless, you all have local examples of this where high-profile cases that are being covered in the media by attorneys who are media savvy help those attorneys resolve their clients' cases, build relationships with those clients, and help market those attorneys for future cases. So let's start, Robert. I want to hear from you. What is newsworthy? When is a lawsuit newsworthy to you that would make you want to write about that case?
I saw that question in there and I was like, that's such a complicated, I mean, that's, I don't know if you have time for an answer to that one. Because, my first response would be interesting. but then there's also sort of important too. I mean, there are these broader issues that are ending up in court, and sometimes things aren't really that newsworthy, but I just want to get them on the record, and so I sort of dispose of them quickly. So I think it's interesting to me, or to my boss saying write that story, or important, or I don't know. That's it in a nutshell.
Jeanette, what strikes you about certain issues and legal disputes and cases that make you perk up?
Well, for us, it's a little bit different because we're always late to the game. I mean, we work 3 months ahead, and often the stories I'm writing about that are legal are done. Maybe there's an appeal or maybe it's over, but it's compelling because we can do it with depth and we can put it into context, and there's an arc. There's some character along the way. It's something. If I'm trying to get somebody who's not in journalism to think of story ideas for me, sometimes I'll say, okay, can you see it as a movie? Which sounds really fluffy, but I don't mean it that way. It's got a driving storyline and a point where you're not going to be sorry you invested the time. So it's a little different. I'm not under the same kind of pressure.
Where do you get your story ideas from? Robert, are you monitoring PACER as the federal courts reporter? Are you monitoring PACER? How much does that influence your cases versus a lawyer or maybe a client or somebody else calling up and saying, hey, there's a case just filed, in case you missed it, it's this docket number?
Yeah, we spend a ton of money on PACER because I try to check the filings every day. I mean, civil and criminal stuff. We've got a couple of things running that will sort of monitor ongoing cases, so if there's a new filing, that type of thing. And appeals court filings, things like that. And then I'm not as good about this as I should be, but some of it just comes from calling people up, what's going on, what's interesting, and then people will call me and say, have you heard about this? Whether that's an attorney or PR person or something like that. Like, are you aware that this is going on? Or if I've written about it before, they say, the resolution of this case is near, are you interested in writing about it again?
So it sounds like what you're saying in another way is it's important to have a relationship with you, because if I build a relationship with you, or if anybody here builds a relationship with you, that becomes a person you might contact to see what's going on in the legal world, cases they've heard about, cases they're working on.
Well, like, if I have an immigration question, I mean, I've worked with Jim before, and so if I have an immigration question, he's, sort of my go-to immigration guy.
Think about that. You heard, I mean, that's good for Jim and that's good for Robert, but think about that in your own local geographies, how you could build a relationship. It's not going to happen within 24 hours or a week or a month, but by building a relationship, by not pestering reporters, by giving them the things that you think they'll want, which we're going to discuss, so we can help you educate you from that standpoint, you can build a relationship. So the federal court's beat reporter in a major city like St. Louis goes to this guy when there's an immigration issue that he either wants to talk about or that he wants to learn more about. That is incredibly compelling, and for a very small investment, I mean, it's a few emails and phone calls occasionally, you're building that relationship. So whereas we hear about newsjacking where they're very much one-off type things, remember, there's more to you building a relationship than just a one-off thing. It's you building an ongoing relationship with reporters in your area, the reporters that you know are likely to be covering the kinds of stories that you have.
And we just talk about stuff like Robert was wondering if someone could find someone's A file, which is your alien file as an immigrant, and it's something you can't do. So we just bounce things off each other.
I should add, please ask questions as we go. Yeah.
Would you be interested in hearing from a lawyer you had never heard from before suddenly, becoming your new friend?
Why not? I mean, we get all kinds of pitches, and the truly effective ones are the ones that Wayne describes, where like, if there's, our governor just had one of his criminal cases dismissed in the courthouse across the street, and there were a number of issues associated with that case, and if someone sent me an email, that's probably preferable. Because sometimes people call me and they just launch into something, and I'm like, you got to ask me. You can't call me at 4:45 and say, and just start, talking. But if you send an email and say like, hey, I see that this is an issue and I'm an expert in this, then, you know, you drastically increase your chances that we will listen to you. There are also people who send us, you know, stuff on everything they do, and the bar goes way up on that person, because it's like, hey, I filed a really boring case today, and they'll send me 20 attachments that are, you know, every piece of paper in the case, and the only thing that differs between that person and one of these people who sends me a stream of consciousness email and conspiracy theory type of thing with different colors and fonts and everything like that is the bar degree, you know. So it's
Yeah.
very helpful. It can be very, very helpful,
I
and
was-
particularly if we're desperate for, you know, I mean,
Yeah.
it's sometimes hard to find somebody who is an expert in something.
Yeah, I was actually going to make that point because it's a little frightening to realize how our coverage is skewed, because there are a handful of attorneys that I know and like and trust, and I will call them. But anybody who calls and says, I know the kind of thing you do, this might interest you, will be great. The nice thing about an individual lawyer is you guys are busy, you're not going to waste time. So I'm very, very disposed toward it. Unfortunately, the law firms that go hire a media person to send out news releases, it lowers the chance, because that person, to prove themselves, is sending out a bunch of stuff. And it's like, oh, guess what? We have 5 new whatever partners, principals,
Paralegals
whatever
and
they-
secretaries.
Paralegals,
Yeah.
and you know, so I'm sorry, you know, that drops it down. So it's much better to hear from you guys about a specific case that you know is the kind of thing that we do. That's direct and that's really helpful, and I don't have to know you. It just has to be a good story.
Will?
One of the things you said you look for was things that are interesting and important. We think everything we do is important.
Right.
And obviously we're wrong.
Right.
Can you kind of define important?
Well, I mean, one shortcut for that would be, is this the kind of story you would tell, you know, you go home and tell your spouse or significant other or whatever, you know, here's what I did today, it was really interesting. Not the kind of thing you guys might talk about with a colleague or something like that, but like, I mean, what kind of case is something that you want to talk about with people who aren't in the industry? You know, because we'll talk about journalism stuff that would, you know, bore you to death. You guys will talk about legal stuff that is hyper technical maybe, and would bore us to death, or you'd lose us entirely. So, you know, we talk sometimes about like talk pieces, or you know, something that gets people talking. I mean, everybody talks about viral stuff now. You know, just in terms of good stories, we could probably have a separate conversation on providing us with video and audio and stuff like that.
Do you come up with your own stories, or do you have like an editor saying, here's the list of things I want you to write about today?
Oh, I mean, for me, I very, very rarely will an editor, the only time that happens is if she sees a press release first that she gets excited about, or she sees something that the competition has and says, we have to match this. But it's all, you know, 90+% self-generated.
Yeah, same here.
So let's talk about news releases for a moment, because as an attorney, I'm often concerned, I often dissuade clients from doing press releases, because from a defamation perspective, it is much better for a reporter to work off the complaint and them to report the allegations of the complaint. They'll be protected from defamation by the necessary exceptions, because you are accurately, the fair reporting privilege, you're accurately reporting a public document. For you as an attorney, I've mentioned this before on the Facebook group, you are not protected by the litigation privilege exception to defamation when you talk publicly about your client's cases. You have to be very careful that when you make public statements, including even in a news release, that you are not defaming your adversary or the your adversary's clients. So statements you make in your complaint are fine when they're in your complaint. But if you copy and pasted them into a news release, you better have the necessary language like as we allege or as we claim. So I'm hesitant about news releases because it's easy for attorneys to get tripped up and not add those magic words that protects them. I'm curious about news releases announcing developments in cases. So for example, should we have an attorney spend an hour and write up a 500-word press release that really only serves to get your attention and direct you to the actual substantive court filing? Or should we instead write a 2-paragraph email? Say, hey, Robert, I thought you might be interested in this case. We filed a case against XYZ alleging ABC. Give me a feel, please, both of you, please, about news releases and your view of the value and its impact on making you actually interested in the case.
I would much rather have the email. Usually a news release is sort of crafted for an agenda, and I'd much rather have something direct and concise that says, hey, go check this out. I just trust it more.
Yeah, same thing for me, although, I mean, that email and a copy of the complaint or the attachment, whatever you filed, whatever's happened, saves me a ton of time.
Mm-hmm.
I mean, I think the only reason to use a press release is if you don't know who covers that beat at whatever media organization you're targeting, or, it does that sort of, it's not spam exactly, but it has the same effect as spam. If you're sending this out to 50 people, maybe you get 1 or 2 people that's interested. If you send that email, that targeted email to reporters cover a certain issue, I think it's going to be more effective.
Yeah.
More effective.
Unless you're having a press conference, and you just want a blanket
Right.
for the people who can't show up at the press conference but want to report on it in some way, maybe online.
I mean, it may be worth your time to go to sort of figure out who in your community covers what,
Mm-hmm.
and you can kind of do that based on the stuff you
Read
see.
what they do, yeah.
There's less and less specialization, particularly I think among TV reporters. As everybody gets smaller.
Mm-hmm. But you can kind of still tell what people gravitate toward, and
Right.
that's helpful.
So 2 points. One, in terms of news releases, we are not telling you don't write news releases. News releases are very
They are.
important for your firm, both in terms of SEO. David Meerman Scott has a chapter in his most recent book, The New Rules of Marketing and PR, about the value of news releases. And he's dead on. One, it helps with SEO because you're talking about your firm, you're talking about cases, and you're talking about events that if people Google those types of cases, it might pop up. But you're also educating your prospective clients and referral sources when they come to your website. Because you might get a referral from another attorney, but you might not be the only person that they are referring. There might be 2 or 3 other attorneys. And if you have a newsroom on your website that's full of ethical and strategically crafted news releases that are explaining to clients what you do for clients and the results, or just that you filed, a claim or you did something, that's impactful. And it's not just litigation. It could be tax and estates. It could be immigration. You should be writing news releases that explain the work you're doing for your clients. So those could be used internally and for the website. I think we're talking here about using them externally for the purposes of getting media coverage. And I have to caution you all, please, 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 please be very, very careful about ever sending a complaint that you wrote and signed to a reporter through email. There is terrible, repeat, terrible case law across the country, including in my home state of Pennsylvania. The PA Supreme Court about 10 years ago ruled that attorneys are not protected by the litigation privilege to defamation when they send even an as-filed court-stamped copy of a complaint to a reporter. The PA Supreme Court ruled that attorneys aren't covered by the privilege because when they send the complaint publicly, the privilege, which covers things that we say that are relevant to a case and that necessarily arise out of the case, think about a demand letter or a complaint, that doesn't apply when you email a reporter, because emailing a reporter and talking to the media, at least in the PA Supreme Court's view and many other courts' views, is not something that's either relevant to a case or that necessarily naturally arises out of a case. If you are in a state where this case law is operative, you will lose you will lose on a motion to dismiss that case. It'll go to discovery and summary judgment because the court will rule, well, yes, as a matter of law, you could be liable for defamation by sending this complaint, but we have to actually now go to the facts and see if it was truly defamatory. So long story short, email Robert, email Jeanette, the docket number. They're big boys and girls. They know how to get the documents from PACER. There may be some times where you have some type of administrative filing or court filing where they can't get it publicly. Well, then you might have to be a little bit creative in terms of how you get it. But if it's a type of document like a complaint that contains allegations and your name is in the signature block, you better think twice, 3 times, even 4 times about sending that document to to a reporter, and really probably anybody who is an agent of you and your law firm, because it could probably it could get connected back to you. So I want to make sure that we all understand that. That's not ethics. That's pure defamation and litigation privilege side of it. All right, so we talked about press releases. How can we as attorneys tailor our pitches to you? I know we talked previously, we had a prep call about this session, and we talked about targeting. And we know that there are people out there, PR people, but also attorneys, who just blast out press releases or emails to people who would have no idea, people who would have no reason to want to ever read anything like that. So how do you find targeting working for people who are attracting you to stories? So what are they doing to catch your eye? Not just the substance, but how are they actually talking to you specifically, Jeanette, and you specifically, Robert?
What works for me is if they say, oh, I read that story you did back a few years ago, and this, I think, would be taking that another step, or something similar that you might be interested in, because then I can relax. They're not assuming that 10 other things are possible that I don't actually do. So, if they're just sort of conversant, that helps the most. It's really not that tricky. It's hard on you guys because you have to read media and watch it and listen to it. But as soon as you do, you're going to know immediately, oh, that's somebody that might be interested in this. It's really not rocket science at all. There's no mystique to it.
And most organizations' websites will tell you what everybody does. I think my job is getting rarer and rarer.
Okay. You're a luxury, but
Sure.
we're glad you're here.
Right. As someone who covers federal courts only, obviously I help out in other beats, but there is, I think as Jeanette said, there is going to be somebody who covers more crime stories than somebody else, or court stories or things like that. And so if it's a court story, preferably a federal court story, or something that kind of an interesting legal issue or something like that, then it's a good thing to send to me. If it's about staffing and like we said before, 5 new paralegals.
Yeah. And I would actually say, even if it's somebody whose work you just like, and maybe they're writing about science or medicine, you could try and say, do you have any interest in this? And I'm talking now in the areas where people are really forced to generalize. At a city magazine, I'm it. So I write about everything. So if there's somebody like that maybe isn't a beat reporter, maybe isn't specifically doing law or crime, but you really like their work, you think that they dig and they're responsible and you like their writing, I would try. Because a lot of us are being generalists whether we want to or not. I happen to like it, but so I wouldn't narrow it down too much.
So I'll add a couple of things. One, think about who typically covers the plaintiff or the defendant in one of your cases. If you're suing a school district, who is the education reporter? That's easy to do. And also, here's a really easy tip. If you're suing a school district and you want to figure out who you should be talking to, Google that school district and the word lawsuit. And you might find your daily newspaper. You might find trade publications. Let's not forget that for many of the types of defendants that we sue, they have trade publications, chemical manufacturing industry trades, pharmaceutical trades. And these people, these reporters, either on the hard copy media or their online component, they need material. They need eyeballs for the ads, and they need traffic. And lawsuits are inherently interesting. As Robert said, there's conflict. There are 2 sides to the story. There's always a theme, David versus Goliath. And again, they're protected from defamation when they report the juiciest, most insane allegations. They can simply say, well, as alleged in the complaint. So they have an interest here in reporting interesting stories. I want to talk a little bit about what I would call advanced techniques for pitching reporters. I want to talk about exclusives and embargoes. I want to read a text to you all that I got from PJ, who can't be here based on the story. She said she's working with an attorney to do an exclusive with her client. It's about police sexual assault, very touchy. So PJ was a reporter who we hope to have joined us today. So let's talk about exclusives and embargoes. Can you give me, Robert, an idea of an exclusive, an embargo, and if attorneys are using those types of tools with you?
Yeah, people use embargoes all the time, and I think it.
Can you describe what it is?
Oh yeah. So here I'll give you an advanced copy of this lawsuit that we're filing next Tuesday, as long as you don't report on it before then. And I've had prosecutors do that. There's a prosecutor who did it one time because it was a DNA case and it was fairly complicated, and they said, we want to give it to the newspaper so you can explain it to everybody else, essentially, because it was just kind of controversial. And so rather than have somebody try to read through a 50-page decision in this case, they can read a newspaper article and process it a little easier. And it's the same thing. I mean, I find it helpful. Excuse me. I find it helpful because, rather than competing with whatever else you have going on that day, you have a little time to look at this thing and maybe they have a little back and forth with the attorney, like, hey, can you give me a picture of your client? This talks about police reports. Can I get copies of those? Is there a video? And you have all this stuff teed up for when the lawsuit is filed. Obviously you have to make sure that it actually is filed. And it's the same as it was when it was provided to you 3 or 4 days before. But, I usually don't have any problem with them. You have to be careful that people don't tie your hands in a funny way. I mean, we always say, like, if you're embargoing this, but if this news breaks elsewhere, or if I find this out on my own, then, then it's sort of.
Do exclusives matter to you based on your beat and your publication? So that would be where we say, okay, Robert, we want you to have this, and we're not going to give it to anybody else until you publish it. So I guess embargoes are a form of exclusives, but not all exclusives are embargoes. So an exclusive would be, again, Robert, we want to talk to you first about it, and then we won't give it to anybody else in the city or in the state until you've reported.
That always seems like more of a TV thing to me, because they're always slapping exclusive on everything.
As PJ texted me, yes.
Right.
Yes. She proved it.
Yeah.
Right. No offense to the it's just they have more competition within themselves. We're the only daily paper in town, so exclusive in the Post-Dispatch.
Right.
I don't know. It's okay. It depends if you don't overuse it. I mean, sometimes people will say you can have an exclusive on this, and I'm like, and I feel a little uncomfortable putting, some reporters will ask people not to talk to anybody else, and I've never done that because it just seems cheesy or ethically gray or something like that.
I can never bring myself to, because usually it's something where they need or want people to know about this, and we're so 3 months out, and I can't bring myself. I would love the exclusive, but I can't bring myself to say don't talk to anybody else. It doesn't seem democratic. It doesn't seem fair.
And nothing's really exclusive for very long anyway,
No.
because sometimes what people do is sometimes what people have done to me in the past is let's call it, there's no News Channel 8, but in St. Louis, News Channel 8 has learned da-da-da-da-da, and the way they learned it was by reading in the paper.
Right.
So,
Exactly.
So, even if it is exclusive, it doesn't last long.
Right.
So when should a lawyer send you a story? Because there's different tensions there. We have a rule against pretrial publicity, an ethics rule. We have.
We can get into that too, by the way, if you want to talk about
Well,
that.
and I just don't, because I don't know, but what if I want to not, what if they want to ask for confidentiality, and I know you don't do that, but what if that's a value to my client? And that could be a value, so when do I play that? Do I want to do it when the case is filed? Because then it's just a he said, she said. Do I want to do it after I settle the case or win it at trial and I won and I got a better story, but then maybe the conflict's gone? So that there's some different, I've always thought in that there's some different tensions going back and forth, and I'm curious as to your view when you want to get that story. And if you're going to talk about that in a minute, I don't know.
And well, I want to hear what you got. I have some thoughts to share. I want to hear their side too.
As a plaintiff's lawyer, you probably want to do it when it's filed because there's a triggering event. I mean, it's timely for us. Something was just filed and it makes all these claims. And that's probably a really good time to do it because whoever is going to be your opposing counsel won't have seen it yet and will probably tell us we can't comment on pending litigation. So you have the soapbox to yourself.
Exactly.
And then,
Exactly.
and then when this thing resolves itself, I mean, there are a couple of mechanisms that we can use in St. Louis to track these things that aren't that common. And it's hard to track these cases. So when it's resolved, that's a great time to do it because it's unlikely that someone's going to be paying attention to that in your local city. I mean, kudos to that reporter who's checking this thing every week or month or day or something like a really interesting lawsuit and waiting for it to be resolved. But that's not very likely.
So, do you have anything else to add, Jeanette?
Well, only that it really is situational for me because I'm doing long form and we're going back and kind of reconstructing the story. So I don't care if it's done. The suspense needs to be in the writing as I reconstruct it. But if I want to be there and cover the trial, then I sure need to know ahead of time, and I'd rather do that if it's a very interesting, compelling trial. So a lot of it depends on the nature of the case.
So, a word about ethics. Mitch and I had a nice conversation this morning about ethics. Most states follow the ABA model rule, Rule 3.6, trial publicity. That tells attorneys that attorneys can't make statements that they, outside of court, that they know or reasonably should know will be made public and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Adjudicative proceeding is a jury trial. If you prejudice the settlement discussions or the discovery phase based on publicity, that's fine. What the U.S. Supreme Court has ruled in a case called Gentile, spelled like Gentile, Gentile versus State Bar of Nevada, is that we are concerned with ruining the jury trial. We don't want jurors to decide a case based on what they've heard, either a lawyer's version of the facts outside of court or evidence outside of court that might never be admitted in court. So, and even in that case, Justice Kennedy said about 6 months, back in 1991 when the case was decided, 6 months was enough time for any taint to be cleansed between a bad story coming out and the jury trial happening. 6 months is enough time to clear it up. As I told Mitch, in 2018, it could be 5 minutes now based on the era we're in. But even in that rule, substantial likelihood of materially prejudicing adjudicative proceeding, there are huge safe harbors. You can always talk, always talk about the claims, offenses, and defenses in the case. If you are talking about the claims you're making, you are fine. Now, you have to be concerned about defamation, but from an ethical perspective, you're fine. You can always talk about the contents of a public record. And you can always rebut adverse publicity if a reasonable lawyer thinks that the publicity could impact the juror. The only limitation on that safe harbor is that you have to kind of stay related to the adverse publicity. So if someone is coming at your client concerning some aspect of that client, you really can only rebut it ethically, focus on that one area. Strategy-wise, absolutely complaint. That is when it's time to talk to the media. As Robert said, it's timely. You are setting the stage for settlement negotiations with the other side. As Robert also alluded to, most corporate defense attorneys don't know jack squat about how to deal with the media. They do it very rarely. They think their client doesn't want them to do it. Their client probably does. And they just don't know. So they give out that stupid, we'll vigorously defend our case, or
Yes.
we have no comment on pending, or they'll say, we don't comment on pending litigation, but we will vigorously defend our case. So they don't know how to do the defense in terms of the media. And what's nice too, newsworthiness is sometimes a self-fulfilling prophecy. If Robert or Jeanette covers a case that you just filed, well, technically that case is now newsworthy. Why? Because you got them to write about it. So you could, as you have more developments in your case, either based on court filings or documents that you've come across that you feel you can ethically disclose to the media, maybe through some public records requests or what have you, you continue the newsworthiness cycle. Again, we'll look at Stormy Daniels. I mean, her lawyer basically dug up these financial documents about Michael Cohen and then has led the media cycle concerning that. There was no additional filing in that case. But the New York Times had an amazing expose on all these documents because he got the documents, he created some type of internal work product, and was fine sharing it with the media. So to your point, I think that the strategy for settlement is going to be in the filing the complaint and publicizing that. The settlement reporting is your marketing. The settlement reporting is you showing the world, hey, look at this case. I just got $2.5 million for this type of case. Goes on the website, and if it's against a municipality or a municipal agency, school district, Department of Transportation, I find like those settlements are of interest to the media because it's taxpayer dollars. Let's go, we have about 8 minutes left, so I want to talk briefly about how you work. We can't see how you work. How many cases how many stories are you working on, reporting on at any given time?
Probably 2 long form, and they're usually about 5,200 words a piece, and so 1 researching and 1 writing, and then about 5 to 8 shorter pieces, and then a lot of online stuff.
She's working a lot harder than I am. Yeah, for me it varies. I mean, it's fortunately I don't have anybody telling me you have to write 4 stories a week or something like that. It's kind of, I mean, I definitely have my slow periods, and then there are periods like the last 2 months where it's been like drinking from a fire hose, and then and you're sort of sloughing off all of this stuff that isn't urgent and hoping to pick it up again later. But yeah, I mean, I try to keep some longer stuff going at the same time as I'm doing these other things, and then depending on how busy I am, sometimes something that I would like to turn into a story, I'm just like, here's 4 paragraphs so I can take this off my to-do list.
And that's why there's value to the embargoes and the exclusives that we talked about a few minutes ago. If I know Robert's generally very busy and wants to bang out a 500-word article about a case, I don't want that. I want 1,000 words. I want him to interview my client. I want him to dig into some documents. So what do? If I know I'm filing a lawsuit a week from now, 2 weeks from now, I get on the phone, and if I trust Robert and I have a relationship, or even if I don't, but I have a hunch, I want to do an embargo or an exclusive, and I say, here, look, we have a case. I can put you in contact with my clients. They're willing to talk. I've got some video. I've got some documents you might want to see. A real-world example of this is I have a client who is going to be suing the state that he's in. His law firm is suing the state for violating federal law regarding special education services to students. Very trendy topic. It involves taxpayer dollars, but we don't want the story to be a 500-word blurb that's just going to get reported on by the local newspaper. We want the reporter to dig in because it's a bigger story. It affects thousands of kids across the state. So what are we doing? We are looking at different reporters who cover the education beat, and we are going to work with them to see if we could secure, through an embargo, an exclusive right to run the first article, and then if that goes well, then we expect tag-along coverage by other reporters in the area. So it's a toolkit. Again, we talk about the media as a tool on your legal services toolkit, or tool belt. I guess kit is far away, tool belt is much closer to your body. You should be thinking about this. Not every case is going to come up where you have this ability, but I'm willing to bet in each of your files in your office, you have a case within the past quarter, past 3 months or so, that could fit the bill either to be newsjacked or a case that could be of public interest had you thought about ethically and strategically and proactively going to the media.
And just let me interrupt for a second. In the example that you gave, probably most of your communities, reporters are not going through the filings every day. I mean, when I was only covering one courthouse, I sort of wavered on whether I should be doing it multiple times a day, checking the civil filings and things like that. But then, we don't have one reporter covering that courthouse anymore. And so we try to check these things, but, it's tough. And that's the newspaper, and we've got a ton of reporters as compared to some other media organizations in town. So it's very, very likely that no one is going to be checking these filings, and the only way that they're going to find out about some of this stuff is if someone tells them.
So I was going to leave this as my final thought. I'm going to not now because of Robert's comment, but I firmly believe that you and me and us as attorneys, for reporters like Jeanette and Robert and the people in your hometown, interesting and newsworthy lawsuits are like needles in a haystack. They don't always know where to look. There are cases filed in state courts with terrible online court systems. Pacer is not exactly Google. But we as attorneys have the key. We know where those needles are. You should be thinking about how you could help the reporters find those needles in the haystacks that are local, state, and federal court systems. I want to ask you, as we wrap up, how do you verify the credibility and authority of an attorney who contacts you and wants to tell you about a case he or she has, or, as I said earlier, wants to comment on a case or a newsworthy legal dispute?
I make sure they're in good standing if I have any concerns about it with the bar, make sure there are no complaints. Word of mouth, look at previous cases, look on Nexus, just to get a feel for anything that seems scandalous. But otherwise, this is a small enough town, you usually already kind of have a feel. So,
Are you judging them based on their website? Are you looking them up on social
No.
media? Are you looking at...
the only time I would pay attention to a website, honestly, is if it looked like it was really losing objectivity. I mean, there was a lawyer that had stuff out there about his case that was really, I thought, questionable. So if they're going over the edge and sensationalizing it, that would make me nervous. Otherwise, I don't really care how polished it is. I just would want their track record, as a lawyer, that they're solid and not in any trouble. And
Robert, when you...
Same for me. I mean, I do occasionally run into lawyers who don't have websites and whose phone numbers are hard
That's
to...
hearsay, by the way. in this
Well,
group.
it's weird, but it's not, it still happens.
Okay.
But yeah, but basically the same answer.
Interesting. All right. We have a couple minutes left for questions. Mitch, go ahead, please.
Just real quick on the last topic, I just had a comment and a question. What I found over the years is there's nothing more important than credibility and trust. And what I found is that if you were to contact my office to follow up on a breaking news story, if I didn't have value to add, I need to tell you that.
Right.
I don't want to waste your time.
Oh, please.
So, well, but you'd be surprised how many lawyers I think just got a roll of the ball. You don't know. So you want to build up trust and honesty with your reporters. But my question is, what I've noticed over the years is we create relationships where I'm in court all the time. I'm not available by phone. And I'll have a reporter reach out to me via email, hey, Mitch, this is breaking news, can you comment on these three questions? And I can respond back while I'm sitting at court and provide you with information to get the ball rolling and then follow up with questions later on in the evening. What are different ways you enjoy communicating directly with lawyers, keeping that in mind when you're in court, but also satisfying your needs and your deadlines?
I mean, I think, because of the different roles that we have, I mean, if a lot of times if I'm on deadline and someone wants to shoot me an email or even a text with an answer to my question, I mean, I'm happy as a clam because I can drop that in. We don't have to. I mean, there are some lawyers I talk to that when I see his or her name in the caller ID, I'm like, there goes 20 minutes, 40 minutes, something like that, and I don't always have it. So I mean, however you want to get the information to us.
I'm always amazed at how free some lawyers that I really trust and respect are with their cell phone. I'm like nervous thinking, okay, is this thing going to ring in court? They're pretty good about remembering to turn it off. But that helps a lot because going through the whole voicemail thing, you're right, is ridiculous. People are in court. By the time they're done, they're exhausted. Text for a quick answer is great, just to set up a time that we can talk, even better.
Before I ask for any more questions, I want to offer you all a gift from me. I typically give this to clients and people who attend my CLEs, but I have an infographic that I suggest that you take and you put by your phone in your office. It's a script for when reporters call. And even though you now have a newfound love of reporters for Robert and you won't want to give me a high five.
No, I want to see what it says.
So what we do, what I advise my clients, is that when a reporter calls you cold, and you're inevitably in the middle of something, don't get into a substantive conversation with that reporter. You are not in the mindset, and they don't want your unthoughtful comments. So you thank them for the call. You tell them you're in the middle of something, but you're interested in talking to them. You ask them what they're working on. Most importantly, you ask, when is your deadline? They have deadlines. Not 2 weeks or 30 days like lawyers do. They have minutes or hours. And then you say, thanks for the call. I'll get back to you by your deadline. It is something that I have found has helped my clients when they get a cold call, they're in the middle of a brief, and they stammer, they stutter. You want to build a relationship, and the way you do that is you thank reporters for their call, you engage them politely, tell them you're busy, they understand, guess what, they're busy too, but you get from them what they need from you, you find out when you have to get back to them, you say thank you, you hang up the phone, and you've now gotten off the phone, you've given yourself some time to think substantively about your response, but you've also maybe made a new friend. Any questions, any additional questions?
I have one. Are you guys at all interested in lawyers calling you to comment on other cases? That are in the news? In other words, it's not a case I filed, but I have an interesting thought on it that I haven't seen reported anywhere else or whatever.
I guess if I'm already covering it, because I'm so limited, I'm just doing that long list of stories I do stretches over time. So I'm absorbed in one single case. I'm not looking for other random cases. You do more.
Like, for example, there's a lot with the autopilot, auto vehicles and stuff like that. There are a lot of things to say about that from the legal side.
Right.
That may or may, that I haven't seen in some news reports. So is that the kind of thing that you would have any interest of? That might be a thing or not really.
When you said you wanted to share an interesting thought, I was thinking, but then when you said areas that haven't been covered, I have a different reaction because particularly if it's, like if you call me up and say, I want to talk about something that's going on in Miami, I'm going to be like, yeah, I would like to be in a position to write sort of like a think piece about something that happened over here, but that's just not my job. But if there's something going on here, or if there's a connection, you're like, did you know that this thing going on in Miami has a really, really interesting connection to St. Louis? Then, you might have hooked me. I'm always interested if someone's like, what's so interesting is that, a lot of times people who are in the middle of a case will be like, well, I can't believe you don't see this, People love to play that game with me. They're like, well, I can't believe you don't, that you can't see what's going on here. And I'm like, you're in the middle of this thing. Or whenever it's somebody who has more access, they've got subpoena power. and they're looking at all this stuff and it lays out this great story and they're like, boy, you're really missing this. And we have a very narrow view on a lot of this stuff. And so if someone wants to guide us and say, I understand more about this than you do and you should look here. Even people that can't talk to me, sometimes I say, is there a document somewhere that would help me out, that you could point me to?
So Tina, I think what you could do is, as an example for what we were just talking about, one, if you're in Orlando, if a local Orlando university or tech company is doing autonomous driving, and there's news coverage around that company or that university opening up that lab, that's when you hop in there and you email that reporter and say, do you know about the legal issues? Likewise, all of the automobile magazine, the Car and Driver, all of the magazines and blogs that have covered Tesla and any other type of autonomous driving systems, those are the people that you want to get to also, because those are the ones who think and breathe that technology based on them covering cars. So again, there's a trade publication aspect, there's a hyper-local aspect of it that I think you'll find when the time is right could bear some fruit. Thank you very much for your time. Thank you for your time.